Everyone say hi to Kelly Raybon. Welcome, Kelly. And
Hey,
this guy
hey.
here has been droning on, putting people to sleep. And he keeps saying prejudicially, prejudicial.
You know, not the most entertaining attorneys. I'm like, where is Kathy Nestor? Can we get her back in the house to wake us all up, please?
She wasn't playing. All right, let me turn this back on.
Robinson should be executed. Have you seen anything like that? Now, that type of voir dire is designed to bring to the jury's attention the very information you don't want them to have. So, just throwing out the vague proposition that, voir dire, the traditional means of curing pretrial prejudice, doesn't deal with the realities of voir dire in a capital case where the prejudicial publicity is as extensive as this one. There is a discussion of this issue in an older case, but it always struck me as kind of really stating the truth of it. In the court, this is an old high publicity murder case, California case, Corona versus Superior Court, 24 Calap 3rd, 872. And the court is characterizing its experience with voir dire as an effective method. And the court says, questioning on voir dire as to the effect of the media's evidentiary disclosures, one prospective juror may deny or admit awareness, another disclaim or admit prejudgment. One may falsely deny both knowledge and prejudice for the sake of a place on the jury. An honest juror may admit knowledge or tentative prejudgment and find himself excluded. Many will sincerely try to set aside their preconceptions and give assurances of impartiality, yet unconsciously bend to the influence of initial impressions gained from the news media. And along the same lines, we have in this case an expert declaration that is discussed in docket 305, which talks about the importance of repetition in causing conscious and unconscious bias in jurors. And the importance of unconscious bias is it's by definition bias that cannot be weeded out by voir dire because the juror doesn't know they've been affected by it. And the expert, this at page 94 of 305, says the volume of coverage in notorious cases can be overwhelming. And studies show that the quantity of pretrial publicity to which jurors are exposed affects their level of bias. Across studies extending back several decades, researchers have demonstrated that individuals exhibit a greater propensity to prejudge defendants when they are exposed to more publicity, both as a general conclusion, i.e. showing a general propensity to prejudgment based on an increase in the amount of exposure, and in response to specific thresholds, i.e. showing that prospective jurors exposed to at least 3 newspaper articles about a crime were more likely to believe there was ample evidence against the defendant. This effect has been demonstrated in both naturally occurring and controlled settings, confirming the validity of the proposition. And along the same lines, the U.S. Supreme Court, in a case cited on that same page, U.S. Department of Justice versus Reporters Committee for Freedom of the Press, 489 U.S. 749, says, the fact that an event is not wholly private does not mean that an individual has no interest in limiting disclosure or dissemination of that information. So the fact that there's already existing prejudicial pretrial publicity out there should not give rise to the conclusion that, let's add some more. Because the court at this stage of the process still has the ability to control this process in a way that will protect Mr. Robinson's right to a fair and impartial jury by a representative jury. And just to say, well, we'll handle it down the road is to ignore the mandate of Maxwell that the court has to be proactive and to take action before the prejudice happens. So we're seeking to prevent future prejudice. It's already existing. There's no doubt about that. But to throw your hands up at this point, this early stage of the case, and say there's nothing I can do about it, we're just going to continue along the same lines, allow these people to keep making these prejudicial statements and hope for the best down the line, and that we won't have to exhaust the entire pool. We won't have to move for a change of venue. And again, there are costs associated with those remedies that we think argues in favor of this motion.
Thank you, Mr. Burt.
Thank you.
All right, I just have a couple of questions for the parties. The intent is to obtain these, and then the court will take a brief recess. I want to discuss issue its ruling, and I want to update my notes. I've been taking notes the whole time. I'll be issuing a ruling, but I also, based off that ruling, will want to talk about what the expectation for the next hearing is, to set the guidelines in place so we all come in prepared, knowing what the expectation is and what we'll be handling specifically. All right, to the defense, most pretrial motions discuss evidence that has not yet been ruled admissible. If the court seals a January 9th motion simply because the evidence might be deemed inadmissible later, wouldn't that set a precedent requiring the court to seal almost all pretrial evidentiary filings?
I think it would depend on the nature of the evidence. In other words, if it's evidence that doesn't go to the heart of the case, the court always has to consider the nature of the evidence. Right. Here we're talking about essential forensic testing opinion evidence. And so that puts it into a category that I think is distinct from any and all motions having to do with any sort of evidence. There may be some evidence that doesn't fall into that category. And I note that on this.
Now, if you remember, that's exactly what the prosecution said. So the same thing he's saying now. So do you think, put a 1 in chat if you think the judge is going to grant this craziness, or put a 2 if you think he's going to reject it and make rules around future requests like this?
Closure. So I read that as saying the court is not really focused on whether there has been a ruling on admissibility. It's, again, what is the nature of the evidence? Why are you trying to disclose it? And I think the court can make reasonable distinctions between, is this the kind of evidence that could cause problems, or is it, in the harmless error category?
Thank you, Mr. Burt.
Sure.
And in offering the opportunity, do the other parties wish to respond to that question? You don't have to. But if you want to, I certainly want to give you that opportunity.
No, Your Honor. Thank you.
All right.
I'll just respond, Your Honor.
All right.
Marissa, you're asked on behalf of the news media again. So just to respond to the sort of the argument that the test should be whether the evidence goes to the heart of the case. That's not really a standard that I'm aware of in case law or the rules. Again, the court goes through the balancing test, and there has to be, specific findings. There could be a substantial probability of prejudice. And here I would just argue that's just not the case. And I will just direct the court to the arguments we made in our sealed supplemental opposition that is very specific to this motion as to why that showing has not been made here.
Thank you. All right, to defense, you noted if full classification is denied, you would seek to file redacted versions. Have you prepared a proposed redacted version of these motions? And do you believe redacting the specific evidentiary exhibits and media links would sufficiently cure your constitutional concerns?
We haven't yet prepared those redactions, but it's easily done because it focuses on the factual portion of the motion. So essentially it would be submitted to the court. The legal arguments absent the factual basis that's discussed in the statement of facts and later referenced in regard to the criteria under the rule, some of the publicity set forth there as well. So it can be easily done. It would satisfy the concern insofar as the motion goes. What you would lose in that, I think, is at the hearing itself, having the court have the ability to actually listen to the evidence. I'm not sure. I think that falls into a different category. In other words, the motion is one thing, but presenting it live to the court, I think presents a different issue. And perhaps that can be addressed by submitting to the court in camera the clips that are outlined in the motion, which that would satisfy our concern. But the only other thing I think could arise is if experts are commenting on something the court has considered in camera, those opinions might disclose that information. So that could be a special problem. But in general, I think redacting the motions and providing the court with a disk or a thumb drive that contained the clips with the understanding that that would not be disclosed. In other words, by providing that to the court, the media would say, oh, you provided to the court, therefore it's filed and we're entitled to it. I think the understanding would have to be the court is being provided this with the understanding it is private. And to answer the court's question, I think those kind of remedies would resolve the issue.
Thank you, Mr. Birch.
Sure.
All right, turning to the state, the defendant argues that publicly filing the motion to exclude forces them to republish prejudicial media links in private information protected by grandma, effectively doing the media's work for them. Does the state acknowledge any risk to the integrity of the proceedings by hosting a consolidated repository of this potential prejudicial material on the public docket?
I think, defendant, you can't ignore the fact that there is a risk that when you repeat something, it's emphasized. Certainly we agree with that there's a risk of that. I think Allgaier is controlling, though, where it says the fact that something is...
I don't know. He seems like he might be kind of slipping their way. I'm not sure if he's going to deny it.
It didn't directly address whether that would risk republication, whether the republication would risk emphasizing, but certainly that's the undertone there in Allgaier. And I just wanted to clarify one point there. If you look at paragraph, just let me grab my computer.
Sure.
Came to class unprepared.
Womp womp. You're missing that sound effect.
If you look at paragraph 16 of Allgaier, this is about the point that Mr. Burt made that defense counsel in Allgaier actually attached the letter to his public brief in the Supreme Court. That was not the decisive factor in Allgaier. All that did was give the court even greater confidence that affirming the district court's ruling to release the letter was correct. If you look at paragraph 16 in Allgaier, about halfway through the paragraph, it says, the district court considered the specific language within the Cobb letter. Cobb is the name of the inmate. The specific language within the Cobb letter and its potential impact on Mr. Allgaier's right to a fair trial. But the district court concluded that given the amount and type of prejudicial information already in the public domain at the time of its decision, unsealing the Cobb letter would not undermine Mr. Allgaier's right to a fair trial. So the district court's decision was based on what was already in the public, the information that was already public when the letter came before the court. The letter at that time was still sealed. And then the Supreme Court does not say, it doesn't question whether that balancing was correct or not. It says we are in affirming the decision of the district court. We note that the letter there's even more information of the same kind that was already contained in the letter because the letter itself was now attached to the brief. So the decision in Allgaier was based on the information that was already in the public domain, even absent the defendant attaching the letter to his brief.
All right, thank you. Court has no further questions. We are right at the noon hour. The court intends to take a 15-minute recess to review my notes, considering the arguments, and to issue a ruling on this case as it relates to what's before the court. And then we'll come back and discuss how we will address the April 17th hearing. Court is in a brief recess.
All right. There we go.
Okay, Trigger, do you think that the judge really in something like this subject at hand, right? Do you think he already knows pretty much what he's going to decide before the hearing started today?
100%.
Okay. Just
Yeah,
check.
I think he's already talked to his colleagues. He's talked to other judges. He's talked to his wife and his kids.
Right,
He
exactly.
spoke to his dog, and he's
Yeah.
like, I'm going to do this unless they just say something that just like blows my mind. My mind is set.
Yeah, this is just procedural dog and pony show. This
Well,
unfortunately not very exciting for the rest of us to watch, but you know, it's procedural.
Well, let's see.
And it's not, I mean, it's not assuming that he's not doing his job. It's just that I think that the facts are what they are, and the case law in Utah is what it is. And so it's not about like saying that he's just checked out up there. It's just really looking at it from the most basic point.
Well, I'm not saying that he's part of all of this whole thing, this whole psyop and everything going on, but he was in the Google Trends searches that Barron found. So far, you know, Barron thinks he's doing a good job. A lot of people say he's not putting up with any crap. He's cutting everything short when they're trying to pull some stuff, but we'll ultimately see. I mean, once they start showing evidence, that's when it's really going to come out if he's on the right side or not.
Well, people are very excited to see the two of us streaming again. So
It's been a while.
it has been a while. I know I've been busy with lots of kids stuff going on. But I'm glad to be back in the house. So thank you so much for having me.
Kelly's been cheating on me. All right, let's see. Looks like Jordan's here. I thought I saw Bays in here as well.
I did. I saw Bays earlier. I only saw one comment in the chat, so I don't know if he popped in and popped out. But
And thanks to the moderators for helping. I know that my timing is never consistent. I'm not like at like 5 p.m. every Thursday. I just kind of jump in whenever I jump in. So I appreciate you being here. And let's see. Thanks to the members. Make sure you guys follow Keli Raybon. I think a lot of you already do. But make sure you check her out. X, Instagram, YouTube, at Keli Raybon. And if you are not already a follower of mine, consider it. My information's here. It's Triggersmart, basically everywhere, or Triggersmart HQ. And for those who are interested, because I've had a lot of interest lately, I've been doing World War III updates and live monitoring. So if you want to check that out, it's actually going to move to Off Script Radio. That's going to move to my second channel. And that'll be in about the next 5 or 6 days. It will all be over there full time and not on Triggersmart. I'm going to keep this channel for the investigatory stuff and obviously firearms.
excellent.
It looks like we have like what, 10 minutes? We got like 10 minutes left. So yeah, this is a good time if you want to like grab a drink or a snack or go to the bathroom or whatever you need to do. This would be a good time to do it. I know some of you are probably sitting on the toilet right now trying to act like you're not. Yeah, I said it. I said it.
You said it. Oh goodness. So you've been doing a lot of work on the war stuff. How has it been kind of making that transition for you?
I think a lot of people who didn't know me from before, I used to have a news channel and that channel has since been taken down and all that stuff because I didn't use it anymore. But I spent
Mhm.
about 6 months doing strictly just news. So I was covering like the story of the day type of thing, and did a lot of
Mhm.
coverage from that and some more coverage. So to me, it's second nature because I already did it previously, and I know I have all the monitoring tools and all that kind of stuff set up. So I enjoy it, but I also know it doesn't really fit what my channel's been doing up to this point. So I don't want to mess up my algorithm. So of course I need to move it to a different channel.
Right.
I want to see you
Well,
cover it.
yeah, I mean, I probably should. I've got something else that I am working on, and I've talked a little bit about it with you previously, but I feel like I was first on the scene to discuss and make a big deal about the TPUSA going into the schools and
Mhm.
this like big push across the country because they came hardcore into Texas. And so I was on that back in early December. I think that was like the first week of December. And now, they are just picking up pace rapidly. And I don't
They
know,
just
it's
had it
quite
Arkansas,
bothersome to
right?
me. Yeah. Yeah, and they've got gosh, I mean, they've got state after state after state lined up, and I just see how all of this is blending together. And at that time, I had mentioned that our lieutenant governor was making this contribution, $1 million contribution, and turning it back around. And then I said, I bet that this will come back around into politics in Texas. And of course, then what do you know? Turning Point then endorses these candidates in super hot primary races. And I just really see now how this whole system is connected. And I hope that other people are really waking up their eyes too. In addition to just looking at what happened on September 10th, there is a bigger picture here that is very important, that choose whatever side you wish to of it. But most important thing is to see what's going on, in my opinion.
Agreed. Someone is saying, Matt, why did you take down your video from last night? I didn't get to see it. So I posted it, and this was covering the new footage from Candace. And then, like 30 seconds after I posted it, I got the YouTube gods coming to me telling me that there were issues with it and that I needed to review it, and it needed like 24 hours of manual review or something. And then they denied it and basically said like I could post it, but it'd be demonetized and all this kind of stuff. So I just took it down.
Wow.
And there's only two things in it that were actually important. And one of them has already been figured out, that the spots that people thought was blood is actually the hand of Dan Flood on his
Do you
back.
think that for sure? Because it really did look like
The more I look at
the
it, yeah, I mean, like, because I go through it frame by frame, slow motion in my programs
okay.
and stuff,
Yeah.
and it's blur. The thing that makes it difficult to see that is because it's blurry. So the fact that it's blurred makes it look like it might be blood that soaked into his shirt or something. But the more you look at it, if you watch from the side view, you can see Dan Flood. He basically puts his hand in that exact spot when he's taking Charlie down.
Okay.
So I'm like 95% convinced that it is his hand and not something else. Because I was all over it. I made a whole video.
Oh yeah.
I was like, there's blood in the middle of his back. If he falls to the side, how the hell is it going to fight gravity and go up his back? Like, I had all this stuff planned out, and then as
That's
people
where
started digging.
my mind was going
Yeah.
fast.
hmm I
But
recorded I recorded a video like 3 seconds after it was done, like
oh,
just like flying through it.
well, you're
So
fast. You're always so quick. Okay. Well, then, what are your thoughts overall on her not releasing the video in its entirety? I mean, it seemed very selective, to say the least.
well, there were three things that, yeah, those three things I called out. So why wasn't it released sooner? Why was it held on to this whole time? Why wasn't it released in the full format, just like to play it and not
Yeah.
them like moving around or whatever? But I know it was a FaceTime. It was like a screen recording of a FaceTime of him showing the video on a screen. So it's not going to be perfect. But my biggest thing is like, she keeps talking about citizen sleuths and the investigators on YouTube and all this kind of stuff and empowering the TikTok crowd and all this kind of
Right.
stuff to do all the stuff. Yet she holds this video for 5-6 months. I don't know.
Yeah.
So, I mean, I don't know if it's nefarious, but it is strange.
Yeah, and then on top of that, I mean, doesn't even show the entire and doesn't say, "Oh, then we stopped recording once he fell down." Or, you know, she didn't say that, "Oh, he started playing the video for me right here." Like, I want to be able to see in the second. She didn't show the seconds before the hit, did she?
Yes. She showed the seconds before the hit. She showed the crowd, but the way they were showing it was very unorganized and kind of all over the place. And it looks like
Yeah, it
her.
was.
Well, it looked like her producer was just kind of like scrubbing around on it and stuff, and she was just kind of like at the mercy of whatever her producer did. So it was very
Yeah.
unorganized. But I mean, I'm glad it's out. But the fact that it took so long to come out is kind of strange, and the way it came out is kind of strange.
Yeah, I want to address what TK Parks is saying here. Um, stop, just stop. I'm sorry. Every time I see "just stop," I can't help but do the ear guys. I mean, that's how Matt and I first started hanging out, so it's only appropriate. But that it was TPUSA's place to provide, not Candace's. Well, okay, technically it was Terrell's because yes, he was acting as a contractor, but he was in possession of the video. And at the end of the day, you guys, like, you still, in my world, I think doing the right thing supersedes all. And we've seen that TPUSA is not interested in providing video. And yes, I mean, should we just feel grateful that she showed us anything? I mean, maybe, but at the same time, you guys, how many millions of people have put their faith in Candace to work this case, you know? And how many of us are working day in and day out trying to chase down every lead possible? And when she's holding on to something that could maybe point us in one direction or the other, or rule out something, I just think it's critical information that should be shared.
The only reason I could think of that she or Baron or anyone else who has pictures and evidence no one else does would hold on to it is if they said they wouldn't show it for some reason for a certain period of time or something, or if there's some kind of legal stuff in the background, or if they're trying to use it to mess with those people that may be indicated in it, right? So if they want to make them like sweat
Mhm.
and stress out about it and stuff, but 5 months, 6 months, I mean,
Yeah.
yeah, I don't know. Someone said link is up. Link is up to what? Is there a link up to the full video?
Someone
Can you
said
follow?
in Rumble.
The full video's on Rumble?
I don't know. I haven't seen her tweet that, but I've seen someone in this chat saying that.
Okay. I'll go look
So
over there
if
real
y'all
quick.
know that for sure, please feel free to. And I see Blindly Gab said definitely ask for it, Matt. She said she'll give it. I know, I won't be speaking out of turn to say that Blake asked for it directly yesterday. He, has her number. He contacted her and she didn't respond. So
Well, you also have to consider how many people she's has contacting her as well. So I don't see that it's on Rumble. I see the video, like the live stream that she did is up, if that's what you mean, but I don't see the individual video that's full access to play and that kind of stuff. We're talking about the video of Charlie from the back, not her video of her showing the footage from the back. I think we're coming back to court, maybe. So, Brian, we're talking about the video that Candace was showing about Charlie from the back. Someone said, Kelly, do you really think Charlie's wearing a fat suit?
okay. So I was just typing out a link or typing out a response to that. I don't call it a fat suit. I know that Jordan Henshaw has called it that, and I think it's every time I hear that phrase, I think of the movie Fat Albert. Is that it with Eddie Murphy or
Oh, you're
something?
talking about,
Anyway.
no, it's not Fat Albert. It's
Or yeah,
Nutty Professor.
Nutty Professor.
Yeah.
Sorry, Nutty Professor. And so anyway, I mean, that's obviously not what we see, but I think that there's, potential for some sort of prosthetics there, but we can't really tell in that low quality of the video. I know that there is a higher quality of the video that exists. And again, at this point, I think it's worth just putting things out there, letting people help us figure things out. You guys want to be part of this too. So y'all don't want me to hoard video and hold on to things. So I'm just trying to put it out there and do what I can.
Yeah, I don't subscribe to the fat suit. If they did anything, it was just if they went that route, it was just Hollywood special effects and makeup, which is much more advanced than a fat suit nowadays. There'd be no need for a fat suit.
Well, it would have been a place. I think the point was that it could have been a place to conceal the squib.
But I don't even think
Does
you
that
need
make
that
sense?
to conceal it.
I see.
You know what I mean?
Yeah.
Like,
Mhm.
the lines are so small, they're so powerful and stuff now, and they're so good at it with the makeup and the blending and everything. They wouldn't even have to go that route.
Yeah. Well, what I think is definitely evident is the way that they carried him out like a ragdoll is absolutely despicable. That there's no way in all of the training that those guys have done that would be acceptable. Like I'd really like to take that video and show it to a professional and have them like weigh in on it step by step.
I've showed it to the guys that I train with, and they said that almost nothing about that entire process was correct. So even the number of people who were moving him, right? You'd have a couple guys with their guns out, and a couple guys moving him.
Yeah,
and they had everyone just moving him, not even focusing on the threat at all.
And Harpole even did training specific to caring for a target while they're still on the X.
Yep. Which is pretty standard for anyone, even people that don't train super in depth. Getting off the X is pretty straightforward. But you have someone Glitchigumi saying what's going on in court. That looks like it's one of your links.
Oh, okay. What's going on in court? Well, we are having a big debate about access, the media's access to court. And so right now, the judge, we're in recess, and the judge says that it should be back probably within 5 minutes, hopefully.
If even that, yeah.
Yeah. Hopefully we'll be back in business very soon.
So this is kind of in line with that same question, but there's two main things. One is, can they have cameras in court? Will it be closed to the public? Because I think it's painting the public's, it's painting the jury possibly, and it would make them be biased against Tyler. And they keep saying media. I'm not sure if they mean like all media, like social media included. And then the other thing that's very important is they're trying to steal evidence. They want to steal evidence from the public to protect Tyler as well. So, and it sounds like the judge, at first I thought he was just going to flat out deny it. But then as things went on near the end, I feel like he might be like 50-50. He's going to try and make both sides happy. Like, well, depending on the evidence, we might close it or not, like just leaving it open. So we'll see. Thanks for the super, by the way.
You guys are so great. I just love the high level chat that we always have. I mean, that you always have, Trigger, as well. You have an amazing group of folks.
Well, if anyone's dumb, I just kick them out. I just ban them.
So there you go.
No, I wouldn't do that. I just mute them. No, I wouldn't do that either. That's messed up. You shouldn't even bring that up, Keli. I'm surprised you said that.
Surprised I said how amazing they are?
There we go. Back in session. Hey, Marty, how's it going? I didn't ban you, my bot, or my one of my other people banned you. So if you got banned, you probably earned it, but I'll let you back in. You're welcome.
Thank you for the patience of the parties. This court has considered the oral arguments made today and has considered the briefing, which has been previously submitted. And I commend the parties for their diligence, their arguments, as well as the quality of briefing that was done on this issue. And so the court is going to issue its ruling on what is requested and what is before the court.
Here we go.
Before the court are 3 motions to classify court records. Defendant's motion to classify as private, motion filed January 9th with exhibits. Defendant's, and which is docket 285. Defendant's motion to classify, motion to exclude, docket 310. And defendant's motion to classify reply in support of motion to exclude, docket 400. The public has a presumptive right to access court records. Open court records assist in educating the public about the workings of government and the decisions being made on the public's behalf. Contribute to the informed debate, allow the public to hold public officers and employees accountable, increase public confidence, and provide material for independent research on improving government policy. The right of access, however, is not absolute, as cited to in Algier. Other factors may favor closure of the records, such as protecting personal privacy, non-parties participating in the court proceedings, and a defendant's right to a fair trial. A court may consider any relevant factor, interest, or policy in both in favor of and opposition to closure in determining whether to classify or close all or part of a court record. In making its determination, a court must make findings and conclusions about specific court records.
He's going 50-50.
Identify and balance the interests favoring opening and closing the record, and if the record is ordered closed, determine that there are no reasonable alternatives to closure sufficient to protect the interests favoring closure. With this legal framework in mind, the court now turns to the pending motions to classify. And as it relates to defendant's motion to classify as private motion filed January 9th with exhibits docket 285. Defendant seeks to classify a motion filed on January 9th, 2026 as private because it addresses evidence that has not yet been found to be admissible, and it is of a nature that could easily taint potential jurors. If the court denies his motion to classify, defendant requests an opportunity to file a public version of the motion that redacts the attached exhibits and details from the exhibit discussed in the motion. Defendant does not provide any specificity explaining why the potential evidence discussed in the underlying motion is of such nature that its disclosure could taint the jury pool. The potential evidence discussed in the motion is technical and discusses the process of scientific and forensic testing of physical evidence. It does not contain any obvious private or inflammatory information. And while the evidence has not been admitted at trial, there is no pending motion to exclude it. In balance, defendant has not provided a sufficient basis for the court to find that the interests favoring closure outweigh the interests favoring an open proceeding and the presumptive right to access. Moreover, as the Utah Supreme Court recognized, even in highly publicized cases, a defendant's right to a fair trial can be protected through the regular, time-honored process for selecting jurors, like enlarging the veneer of potential jurors, utilizing a detailed juror questionnaire, and conducting a thorough voir dire of potential jurors. Defendant's request to classify the motion filed on January 9th, 2026 is respectfully denied. As it relates to the motion to classify, motion to exclude, docket 310, defendant seeks to classify his motion to exclude cameras from the courtroom because the motion compiles a litany of unfairly prejudicial and oftentimes inaccurate electronic media interviews, comments, and photographs Furthermore, the motion references court filings that are classified as private and references the publication of private information of individuals involved in this case, allegedly in violation of law. Defendant does not provide any citations to the underlying motion to aid the court in identifying the potentially private information. The court is sensitive to the amount of pretrial publicity generated by this case, including an extensive amount of public commentary and inaccurate or conspiratorial descriptions of alleged evidence supporting or negating defendant's guilt. A substantial amount of this pretrial publicity is organized and memorialized into defendant's motion. Because the references to pretrial publicity are, by their very nature, already contained in the public arena, interests favoring closure are greatly diminished. And this citing to State v. Algier. The public already has access to the majority of the information contained in the motion. Upon balancing the interests at play, the court determines that defendant has not shown that the interests favoring closure outweigh the interests favoring access to the record, with the exception of the potentially private information referenced in the motion to classify. The court orders defendant to file a version of his motion to exclude cameras, referencing docket 305, that redacts private information referenced but not specifically cited in his motion to classify. The redacted versions of the motion to exclude cameras must be filed with the court by the end of business on March 30th, 2026. If no redacted motion is filed by that time, the court will reclassify docket 305 as public. If a redacted motion is filed, the court will maintain the private classification on docket 305. Accordingly, defendant's motion is granted in part and denied in part. Finally, turning to the defendant's motion to classify reply, docket 400. Defendant seeks to classify as private his reply memorandum in support of his motion to exclude cameras from the courtroom. Defendant argues that his reply memorandum should be private because it references portions of the motion to exclude cameras, which he has also moved to classify as discussed in the ruling on docket 310. Defendant does not cite any part of the reply memorandum that references potentially prejudicial information in the motion to exclude. Based on the record before it, the court concludes that defendant has not provided a sufficient basis for the court to find the interests favoring closure outweigh interests favoring access to the reply memorandum. As such, defendant's motion is respectfully denied. I will go ahead and sign this order, and it will go into the record. With this in mind, counsel, how would we like to proceed? What I want to turn to next is this upcoming April 17th hearing, how it will be conducted, and so we all have a good idea of what to expect and to prepare for. And so first, I'll hear from defense in regards to your expectations on moving forward, given the ruling of this court, and then I'll turn to the state as well. All right, Mr. Burt.
So, Your Honor, we anticipate calling several witnesses. One witness would be in the nature of a foundational witness who would summarize for the court the nature and extent of the publicity. Would be testifying to certain things like publication, scope, number of times certain articles have been referenced. We would be playing for the court the various clips that are referenced in the motion as well as others not referenced to provide the court with an overview of what we think the court needs to look at in terms of the nature and extent of the publicity. Then we would also be producing a expert witness whose declaration has already been provided to the court and to the parties. And that expert would testify to the facts and opinions outlined in the declaration that is attached to document number 305. We'd also have a third witness potentially who would be testifying to a laying a foundation and testifying about a public opinion survey that is in progress right now. And that would be the extent of our evidence.
All right. Thank you, Mr. Burt.
Sure.
To the state.
Wait, they're doing a public opinion survey, but they want to block the public's opinion?
Right.
I would anticipate that the state would be calling one witness, and it would be in the nature of a foundational witness to just talk about the nature and the extent of publicity that is negative towards the prosecution and or negative toward Mrs. Kirk. And I believe that would be the extent of the evidence that would be presented from the state's side.
Thank you. All right. Any other input from other parties?
Your Honor, the media does intend to be there, but we don't intend to try to complicate matters. We'll be there to make argument, as would be helpful to the court and to protect the interests that media believes may not be addressed in the other argument, but we will sit on the side table there as well.
All right. Thank you. Thank you to all parties. I appreciate that information. Given the detailed motion filed January 9th, the court will read and prepare as it already has for that. And so the court finds it unnecessary to present all that evidence verbatim. The court does not need to see the video clips. And if the defense wishes to give summaries of what's in the motion, the court allowed the overlength memo to be filed with the intent of allowing you that ability to put in detail what you want to be considered and include your argument. And so the court accepts that and receives that and will review it thoroughly. But for the benefit of this hearing coming up, the court does not feel it is necessary to replay what is listed in the motion. Again, if you wish to give summaries of that, I understand that's going to your argument, but to go through it all again as detailed in the memorandum is not necessary for the finder of fact, the court. And so I will, that is one of the guidances I wish to give. In regards to the witnesses, that is fine. What I would ask is that your witnesses be succinct, on point, and let's stay focused on the issues that are before us. My fear is that we start veering in other areas that are not germane to the issue that's before the court. And this goes for both parties. I'm looking at Mr. Burt, but I equally am considering the state as well, because you indicated you're calling a witness.
They're buffering.
Uh-oh.
They got him.
Got him.
New judge.
And so I ask that you prepare that witness to stay on point and to focus. I want us to be focused and addressing. I also wish to encourage the parties to give your argument the weight that it deserves. This is an important issue, and I encourage both parties to be fully prepared and argue it. This is an important issue. I recognize it for both Mr. Robinson, for the state, for victim representatives, and for the issues of open and transparent courts. So the court is prepared and will be prepared at that hearing to hear the arguments. And I anticipate, unlike today, I will not be issuing a ruling on that day. I believe that what will be argued, the court needs to let it percolate, to examine, re-examine the motions, examine the notes to ensure that the ruling the court makes properly balances the constitutional rights of Mr. Robinson, Ms. Kirk, and the concepts of open and transparent courts. With that in mind, counsel, is there any other issues that we need to address? Mr. Burt.
Your Honor, two questions. We had anticipated filing with the court either a disk or a thumb drive that contained all the reference electronic media cited in the motion. I assume from what the court said, the court has no objection to that.
No. And well, to the state, any input on this request from defense? All right. Mr. Grunander is submitting on it. So I'll accept that and I'll receive that to review just to ensure, because sometimes
Just so you guys know, there was something that was submitted or supposed to be submitted. This either 28 or 58, I can't remember, terabyte drive with more information and more evidence on it. I'm not sure exactly what's on that drive though.
That is online, dated October 28, 2025, from a group called Human Events. And it's addressed to Your Honor, and it's in the nature of a brief on the closure issues we've been discussing today. It indicates at the bottom that it was CC'd to the parties, but discussing with the prosecution, neither party has actually received this. I was curious as to how the court handles, if it does, letters of this nature where people are, unbeknownst to the parties, providing opinions, and in this case, legal briefs to the court, which I assume the court is not looking at, but I wondered, we don't see this filed in the docket.
Right. So that would be ex parte communications.
Right.
And the court has not reviewed that. Do we have a record of that? All right. What is the request of the parties? We have a record of it. I haven't reviewed it. It wouldn't be proper for me to do so, so I have not. What is your request as it relates to that particular brief?
As long as that's the court's ruling, that was our concern.
Okay.
And just to make clear that in fact is the rule, is what we were after.
All right. Thank you, Mr. Bird. I
Thank
appreciate you addressing that.
Sure.
To the state, any final issues?
Just briefly, Judge, there has been discussion today about the status of the April 17th hearing itself, whether it will be open or closed or portions of it. I'm assuming that that'll be addressed first thing on April 17th.
It will. I wanted to see if the defense wishes to file that motion in private that the court referenced in its order, and then I'll take it from there to see if there is private personal information that is anticipated being argued. And so I want to make sure that that's fully vetted out, that the parties see, and that we can prepare. I don't want to simply say it is. The presumption is it will be open, but could there be a portion that's closed? Absolutely. I just don't want to state how much or how long, because I don't know what the depth of that information. So I want to review that, but the anticipation is it will be an open hearing. And again, if there is a portion that dictates that closure is appropriate after balancing all the factors, then there will be a closed portion. Thank you,
Understood.
Mr. Commander.
Thank you, Judge. And then lastly, Mr. Novak did forecast a motion with respect to the preliminary hearing. So I don't know if we're going to discuss that further today. So
that's right, Mr. Novak. You talked about that. I said we would revisit it. At this point, what I anticipate is let's go ahead and brief that so it's fully briefed. Right now, it seems a bit premature because I'm not sure when that information is going to be passed over to the other side, how that affects how it's processed and reviewed. And so I'm happy to set a briefing schedule. It sounds like both parties are aware that the scope of what discovery could be coming over, but may not know all the details because it hasn't been passed over. Mr. Novak.
So that's fine. We're happy to brief it. And I think we should, in the time permitting, set a schedule so that
Absolutely.
the court can rule on that before its schedule gets worse. What counsel for the state told us yesterday is that they hope to receive certain materials in the next week or so. We also received yesterday, separate from the forensic sciences, a hard drive that has the images of all of the seized devices. Okay. At least one piece of evidence that I think that the state wants to present at the prelim is somewhere in one of those devices in theory. The state may have another way to present some of that evidence, but we don't know yet. So that's like an additional piece of that. And we, of course, haven't opened that box. We haven't sent it to the right expert. We do know that once we get all of the ATF case file materials from their forensic work and the ATF and FBI data files that we don't have from their forensic work, that it's not just about counsel receiving this, obviously, Your Honor. There's nothing that we can do, for example, with proprietary scientific data that has to be run through software that our experts have access to. So it's not like, oh, we got some information, we're ready to go. That's just what if I didn't adequately express that this morning, I wanted to do that. So we can brief it. It sounds like it should start with Mr. Robinson's motion to continue. And I guess the question is, working backwards, when does the court want to hear that motion?
Well, I certainly want to address it before the preliminary hearing itself, right?
Sure.
That would be appropriate. Well, how quickly could you have that motion filed? I guess that gets the train on the track.
I think it could be fully briefed if everybody is cooperative about that, so that it's ready for submission before April 17th.
All right.
Okay.
That's great.
All right. So
I mean, that's basically a month and a couple days to brief a important but discrete issue.
Of course. And so is that, how much time would the state need to respond?
We could do it in a week.
All right.
I know the rules allow 2 weeks, but with the truncated schedule, we can do it in a week.
So the 24th of April, that would be the preceding Friday.
The 10th. I'm sorry, I'm misunderstanding.
So
I was suggesting, if I may, that we would fully brief it so that when we are here in person with Your Honor on April 17th, the court can hear argument if necessary and issue a ruling.
so are you saying your motion as well as the other side, or what's, I want to make sure.
Yeah,
I
I'm
understand.
saying that we can file our motion. Let's just say we need 10 days from now, or maybe
Okay, I see.
2 weeks to file the motion. And the state saying they have a week, maybe we have a few days for a reply as necessary, and it's submitted sufficiently in advance of April 17th, since we'll be here on that day, for the court to actually hold a hearing on the motion to continue.
I see what you're saying.
Does that still make sense to everybody?
So just for clarity, you'll have your motion filed within 2 weeks, which is March 27th. And then state can have its reply by April 10th. And I think that's what Mr. McBride was alluding to. And then on that April 17th, the court will be prepared to hear argument on that as well.
I think Mr. McBride said they need a week. We want to file a reply, although we won't need a week to do a reply.
Okay, so I see. So from the 10th to the 17th, if you wish to file your reply of April.
Our response, April 3rd.
Okay.
1 week from 27th.
And then by the 10th.
Definitely.
All right.
So it's the 27th, the 3rd, and the 10th.
That's correct.
So we're figuring out the final details. But I would say at this point, we're basically done with the ruling for today. So they're just working out all the little intricacies of the next one. So what do you guys think? If you think this was successful, put a 1. If you think it was went against what we would expect, put a 2. Like I said, a lot of people are saying they think the judge is doing a good job so far. It's very early. We're not even into evidence or anything yet, so we'll have to see how all that goes. But what do you think, Keli?
I mean, look, we're just kind of kicking the can down the road a little bit, but at least we're moving in a forward direction. I was kind of excited there hearing about this human events thing. I didn't catch exactly what it sounded like. He had sent supposedly, or the entity itself had sent a letter or some information or something to the judge, but then had CC'd, I guess, the other parties, but then they said that they hadn't officially received it. Is that how you heard it?
I missed that part completely.
Okay. So, it'd be interesting to go back and check that out, but I don't know a lot about, I didn't really know anything about human events. I just started searching it anyway. So Jack Posobiec is the senior editor of this right-wing site. And it's funny because the Wikipedia site lists him as a conspiracy theorist. And so I just think it's so ironic considering how much they love conspiracy theorists. But yeah, there's so many twists and turns of this. I'm curious to hear what it was that had been sent and what the angle was, because as you know, he's very outspoken on X. He's made sure to insert himself into every little nook and cranny of this thing.
Yeah, he's been very outspoken. He's very pro the official narrative, as far as I understand it.
And he's like works for TPUSA too.
Yeah. Yeah.
He wears many hats, shall we say. He wears many hats. Oh yeah, and he's got the military background too.
Which fits everything that Candace has been talking about. Yep. Very, very interesting. Let me make sure I didn't miss any supers.
Dig into that a little later.
I don't give a damn. Thanks for the super. Private company owns the footage. Candace wanting to show it and being legally able to are different things. Copyright doesn't care about intentions. Loopholes exist, but exposes you to litigation. That's risk management, not bad faith. Well, if that was true, then she just broke that by showing it yesterday. So why couldn't she have broken that 5 or 6 months ago? But I get what you're saying. It makes sense. There's also the aspect too of like the fact that I don't know if he knew she was recording it. Right. That's another piece of it too. Did he say you're welcome to record it on FaceTime and I'll show it to you? Or did she just record it on her own? That's another legal thing too, possibly.
But I mean, she does have lawyers at her disposal. Let's be honest. She had been certainly in mass communication with her attorneys for months now over so many issues involving this, you know, whether it be remember the whole ordeal with her lawyer's address and this and those connections and the threats on her life. And, you know, then of course, however, she was able to finally complete the contract with TPUSA and Erica coming to see her. And it's not like she doesn't have access to attorneys to be able to get advice.
Well, and it's not like they're hurting for money either. Her husband does pretty well for himself. So
I don't give a damn. I love you. I adore the work that you do, but no, I'm not paying for her lawyers, but I don't think that, yeah, I mean, I don't think it's would be too expensive. It would be a worthwhile question given the amount of super chats and what, even if she was a solo by herself operating, you know, she could handle it.
Roger Lane, how's it going? For people that don't know, probably like the last 50 or 60 free gift memberships that you've gotten on my channel have come from him. So make sure you show him some love. Let's put some thumbs up or hearts or thanks, Roger, or something down in the chat. He's been killing it lately. Much appreciated. Yeah, I agree. The footage didn't really show anything new. Aside from that spot that we thought was maybe blood on his back, there's not really much different. The only thing I did notice is something that Jordan talked about with you yesterday, and that's that the microphone looked like maybe the whole mic was still there, angle. So that's something I was going to speak with John about and see what he thinks, see his opinion on it. But it did seem that there was more there than just the clip and the clasp underneath it.
Right, because he was kind of tilted, it almost from that angle. And granted, I mean, the camera, sorry, you can't really see me, but the camera was, you know, up and maybe tilted down a bit, you know? So yeah, it looked like he had lifted back a little and then to the side.
He did it again. Roger. Oh my gosh. I think he broke the record for sure. He's just showing off at this point, but we appreciate you, Roger. Yeah, so I think as far as that goes from the angle that I was looking at it, the main thing I'm looking at is not just the angle of the camera, it's where that magnet is. If you look at the piece that is connected to the microphone, it's a rectangular piece, right? This under his shirt. But if you look at his shirt in that shot from the back, it looks like a square. So if the rest of the microphone had blown off, you wouldn't expect to see a square. You'd expect to see a rectangle. So that's why I thought it was very interesting.
I want to say one more thing too about the Candace lawyer issue, right? Is that to me as a journalist, it's not just about the money that would be spent on asking that question to an attorney, it's just the right thing to do. And so I don't know if she was in those conversations. I do think that there were enough people out there and asking, hey, when are we going to get to see the video? When are we going to see the video? And then she could have at least like maybe updated us somewhere along the way and saying, you guys, I just want you to know I'm working with my attorneys to see what I can do to release the video. I don't recall ever hearing that. Because at the end of the day, that would be protecting herself. It's not about the money. It's about the principle of the matter to me.
Let's see. From looking for answers, wow, is this stream about hating on Candace? I think some people are confused about what hating is. If people are talking about things overall that are just going on, that's not hating. Hating would be saying that she is terrible or bad at something or a criminal, or like the TPUSA people are saying she's demonic and those kind of things. Talking about her lawyer situation or talking about, when she decided to share the video. Those are not hating. Those are just talking about facts.
Yeah.
So you have to be really careful when you're saying stuff like that it's hating. I think it's really easy for people to jump to that conclusion to try and be divisive, just like they do with the Democrats and Republicans. Someone says anything about the other side, even if it's just a valid criticism, and people are like, oh, you just hate whatever. No, people need to be smarter than that. You need to make sure that you're using your brain and your logic in these situations and not just jumping to conclusions and picking a side instantly. That's not how life should work. So that's not against you specifically. I'm just saying people in general. Let's see. Yes, YouTube does give memberships at random. So, and I don't know about that accept gifts setting. I've received them before, so I might be on by default. But for some reason you don't want a gift, then I guess you can turn it off. I have a few memberships that I didn't know about. I went through my email. They're like, hey, you're a member of this channel. I was like, oh, great. Caught a couple members live.
Somebody gifted me a Paramount Tactical one for Christmas.
Lucky. Lucky.
Needless to say, I've never utilized it, but somebody sent it to me on Christmas Eve. Whoever that clever person was. Thanks.
Sarah and Brian, thanks for the super. Whose video is it in the first place? It belongs to Terrell Farnsworth, who was the camera guy. It was their camera that was recording it. But actually, that's not true. So the original video that was recorded belongs to him and the company that he works for, or whatever you want to call it. The video she showed was the video she recorded. So technically, she owns that video and the rights to that video. Let's see here. Lisa Edenborough, thanks for the super. People were saying yesterday there was a red light dot on CK's shirt. Baron quickly looked and said he'd seen it too. Are you talking about like a laser dot? Or are you talking about the red splotch that looked like blood they were talking about before? I had
Was
not
it on
seen
the back of the shirt or the front of the shirt or where? Yeah.
Yeah, I mean, obviously that's a shot from the back. So if you saw it on the front, we wouldn't have seen it in that video, I don't think. But yeah, if you can give a little bit more information, that'd be great. I'm not sure if you guys were talking about like a sniper laser or something. But if you're talking about the spot that looked like a blood spot on the lower part by his chair, basically everyone's found out since then that it was Dan Flood's finger. And at one point you see 3 fingers and it looks like there's more blood, but it's actually just Dan Flood's hand and it's blurry. So, and this on X. So if you really want to go validate, you can go search that on X and there's all kinds of posts talking about it, but it seems like everyone's accepted that it was Dan Flood's fingers. Let's see. Yeah, on the back by the chair. Yeah, that's the spot we're talking about with the fingers. Yeah, because trust me, everyone, the second they saw that, I recorded a video. It was like 20 minutes long. I'm going into how, it looked like there's blood coming out from that spot in the back and everything. And I was ready to release it. And then I started going on X and looking, and it's like, oh, it's his fingers. And I was like, no. And then I started, looking at it closer and saw that it was just blurry fingers and everything. And then saw a video from the other side showing Dan putting his hand in that position. I was like, oh, okay. So I just had to scrap the video. But that would have been a whole different level. If that would have been true, that would have changed the entire case. Let's see. Thanks for the super. Are you saying Candace recorded the video? She recorded a FaceTime video of the original video that Tara was showing her, if that makes sense. So she recorded a video of the video being shown to her. Let's see. I'm just looking to see on your side as well.
I'm curious who. Okay, I don't know. I've been trying because there's so many chats coming through. Oh, you just got another super chat. Maybe I think chat's on fire.
Yeah, I'm trying to keep up. Chat's moving pretty quick. I couldn't even imagine like a Candace chat with 100,000 plus people trying to keep up with any of that. That's probably why she doesn't.
Producers. Yeah,
You know,
producers
it's
are
impossible.
doing it all for you.
And yes, Kimberly says, thank you for all the donations and memberships. And also, everyone, if you can, say thank you to Kimberly and the mods for being here and for keeping this clean. And I know that Nightbot is very helpful, but they also look for other people that are just trolling and that kind of stuff. So make sure you show the mods some love. We definitely appreciate them being here.
Absolutely. Thank you guys so much.
Big Chap is saying 5,000 boots in Iran, official scope, James Lee X post. I heard that they were going to be putting Marines in Iran. Let me look that up. Do you want to do some chat stuff, Keli, while I'm looking that up?
Yeah, absolutely. I can't pull it up right now, but I
don't. Are there news? Yeah, there's no other super chats right now. Wait, yeah, there is.
Yeah.
Do you want to do that one?
Sure. Okay. Right. F-35 JSF. Here's the thing. Some getting all upset about comments about Keli. She's bulletproof. Strong women are. I married one. Obvious to most. Thanks, Matt. Well, thank you for the super chat and thank you for the comment. I mean, I don't know if I tried to respond to you earlier, but I don't know, for whatever reason, YouTube didn't. It must have had some trigger words in there, but I don't know if I'm bulletproof. I mean, I think I've got a big old heart just like everybody else, but I
bulletproof on camera.
Yeah, and then I get a lot of mean comments too. So of course I'm happy to take the kind ones as well when they come through. So thank you guys so much. I really do appreciate it. But I love some good discourse too. And so I don't want to live in an echo chamber. And that's why I do my best to always engage with the chat, even those that disagree with me.
Okay, so I see, let me show this here really quick. So someone mentioned, I think it was 8,000 or 5,000 troops. So I've seen a few, but it says the Pentagon just approved deploying boots on the ground in Iran for 2,500 Marines. There might be more than just the Marines, so maybe that's where that 5,000 comes from. But everyone's saying it's a suicide mission that Iran's just waiting for them. So I don't know what their plan is, but anytime you have a situation like this, where you go into another country and you blow everything up and you kill their infrastructure and you take out their leadership, obviously they didn't take out all the leadership, but they took out the main leadership. That leaves a situation where there's a vacuum for power. So you have to prevent that civil war from happening. And then you also have to take care of the people. So you have to make sure that their water is running and their electricity is up and that kind of stuff. So there's a ton of work to be done. Not to mention the nukes and everything else they're saying that they have and the uranium. They have to go in physically into those facilities and they have to secure that. So there's a ton of stuff they still need to do, and it requires boots on the ground. I know Trump originally was saying that it wasn't necessary to do troops, but obviously it is. And I think he was saying that just to like slowly desensitize people to the idea of it. But obviously they're there now, unfortunately. But thanks for sharing that.
I'm trying to find the comment, but this, and sorry, I'm not going to say the name right because I don't know. Charakatare.
Wow.
72,000.
Wow.
What? How would you say it?
Charakatare. I don't know
Yeah.
which one you're talking about. Let me see.
Yeah, Charakatare, 72,000. But there were a whole bunch of comments, but there were some of them that were, I don't know, critical of me or me and Blake. And I want to make sure that I am addressing them, but the chat keeps moving so fast every time. So anyway, let's see.
That's the only one I can find.
Okay. So Candace lied on the video footage. She made a deal about asking for the footage, but he would not send and suggested Zoom. She only argues, she said, and held it all this time. Blake and Keli did same. Oh, let's see. And then let's see, she just said, just one of the many things about Keli. She just said another, he or she. One of the many facts about Keli is at 20, she gets the, okay. This is okay. So this person actually does listen pretty close to me. We'll come back to this one in just a sec. But I don't know what you're talking about with Blake and Keli getting footage, because Blake has been getting footage, since early on, before I ever even knew him. I never spoken to him. Like, all of that is long documented on X. So I don't know. I'm happy to clarify any of the questions you have. And then they had just brought up that one of the many facts about Keli is at 20, I get the job as the assistant to the Republican Party leader. And yes, this is true. I talked about this on my stream the other night, saying that I have so much knowledge that I really, try to weigh in on things, like back when I was 20, which was 20 years ago. And I worked for the chairman of the Republican National Committee as an intern. So, I'm here.
Kelly's an informant. She just admitted to it.
No,
All right, so for the people,
absolutely not. I assure you, from politicians to criminals to cops, they all feared me. Okay.
So big chap. That's because she's in the mafia. She's part of the system. They fear her. She has people
I
that
can't
can
win
take care of
around
people.
here. I can't. Well, hey, then I'm good to have on your side. All right.
Exactly. That's why I had you on. I was scared.
Thank you.
James Lee's post. This is big chap. So I followed up. So he has one post where he's saying it's official boots on the ground, and he's referencing someone else saying 5,000 Marines, but all the official things say 2,500. So it's not that I skipped. It's just, even like in the same hour, he has one that's 5,000 and one that's 2,500 that he's referencing other people. I don't know which one's true. Obviously, you'd want to go to the White House and get official numbers from there. But yes, there's U.S. troops, boots on the ground. And let me see if this is more official. The Pentagon is moving additional Marines and warships to the Middle East as Iran steps up its attacks. And this says American forces, amphibious groups, Marine Expeditionary Unit, typically consisting of several warships and 5,000 Marines. So they're saying that's typical, but they're not saying that 100% that that's what's going. And then the other source is saying Pentagon, Expeditionary Unit of 2,500 Marines. So at least it looks like at least 2,500 are going. I don't know if it's going to be 5,000, but I'm sure this is going to go up over time, right? As there's more need, there's going to be more people sent, and not just Marines. So kind of crazy. I don't give a damn. Thanks for the super. Screen recording doesn't erase copyright. Private company still owns the footage, which is probably why it was delayed. Critical open combo works both ways. Yeah, that's between them, what happened with that. But obviously now it's public. Her version of the recording is public. So I don't know if she worked something out or not. But we saw the best version of it that we have so far. Maybe that's part of it. Maybe the fact that she only showed pieces of it and was like adding commentary and all that kind of stuff to it frees her from the legal piece of it. I don't know. Just like with news and everything else, the fair use. All right. I think that's all the super chats. Court is done. So I think we'll go ahead and wrap this up. But we appreciate everyone being here. Make sure you guys hit that like. Make sure you subscribe. If you want to subscribe to Keli, this is her information here. It's Keli Rabon, KeliRabon on X, Instagram, and YouTube. And if you don't subscribe, she will send her henchmen after you because she's part of the system. And if you want to follow me, like, subscribe, and share. It's Triggersmart on YouTube and pretty much Triggersmart HQ everywhere else. And we appreciate everyone being here. We appreciate the moderators, super chats, memberships, everything. So you guys' support is what keeps us going. So most likely, Humble Beginnings says you sent 2 supers. Oh, you just sent it.
Yep, I see.
Okay.
I see.
Sneaky. All right, go ahead.
I appreciate Candace, but everyone can be questioned. We shouldn't idolize someone or believe that they are infallible. Thank you for the super. And yeah, at the end of the day, it's not about attacking someone. It is that we're all out here working, and I think we should all be subject to questions. I mean, that's the only way that we get better, you know? No one should be held as a false idol and untouchable. Not even Charlie. I mean, so many people have martyred Charlie, you know? I mean, like, I just, everyone should be subject to questions, myself included.
Interesting. So we just had a couple of supers that just popped in that weren't there before, like even mixed into the other stuff. So let me make sure I don't miss any of these. We got that. Here's another one for you.
All right. Does anyone know who put out the first video with all of the blood that everyone saw when it happened? The video yesterday showed none. Also, Candace is no dummy. Okay. The first video that everyone saw. It depends on what angle you mean. Right? Trigger, what would you say?
I think the first one I ever saw was from his left side.
Yes. That's the first one that I ever saw too. And that one that I recall was from, I mean, I watched it on X, but it might have originated on TikTok, but it was I Am Ricky Diaz. That name and his little graphic will always be like embedded in my mind because, you know, it's traumatic.
Lisa Edinburgh, I'm not sure. Brandon said he would look more and let us know. Thought you might like to know more, or thought you might know more. Thanks for the super. Yeah, that's something I didn't. If you're talking about the bloody spot, we've talked about that. But if you're talking about like a laser or some other kind of like infrared dot, well, obviously you wouldn't see infrared dot with the naked eye, so it would have to be some kind of laser. I have not seen that, but I mean, I might ping him and see if there's something there, something to look into. Let's see. F35 JSF. Thanks for the super
We did
chat.
that one, yeah.
Yeah, so you did that. I think that is it, unless someone's sneaky again. All right, let's hurry up and end before people sneak another one.
Okay, thank you guys so much. This was so much fun. Trigger, good to be back in the saddle.
Yeah, for sure. All right, awesome. Yeah, someone's saying Trump's sending 5,000 Americans. Yeah, at least 2,500, maybe 5,000. Probably going to be a lot more being sent. But yeah, make sure you guys like, subscribe, and share to both channels. And we will probably be trying to keep covering all the different court cases. The next big one is supposed to be in April. Mm-hmm. So I think that's actually going to be going over evidence, as far as I know. So if that's the case, that one should be very, very interesting. And thanks again to the mods. And we will see you on the next one.